back to The Verdict, a podcast from MLMIC Insurance Company. I'm your host, Tammie Smeltz. As we celebrate our 50th anniversary, we continue our mission, delivering clear, essential insights to help you navigate the complex world of medical and dental professional liability. Join us as we cut through the noise, bring you expert perspectives, and guide you on protecting your practice and your patients. Be sure to like and subscribe to our YouTube channel or wherever you listen to this podcast. My guest today is Nancy Mae Skinner, Managing Attorney of MLMIC's Legal Department. Hi, Nancy, and welcome back to The Verdict. Last time we spoke, we talked about the amazing legal services that we offer to our policyholders. Today, we're going to talk about one of our most popular educational programs, Healthcare Law Review. When did MLMIC first launch this program?
So we started doing the Healthcare Law Review in 2006 when we were doing network meetings, and those were held throughout the state for regional groups of insureds. And then the Healthcare Law Review developed into a regular part of MLMIC's annual risk management conferences that were held in Colony and Syracuse. In 2018, we expanded the exposure of the Healthcare Law Review through a partnership with HANYS Healthcare Association of New York State to present the Healthcare Law Review to a wider audience, now, several hundred, including HANYS members and MLMIC policyholders. We position the Healthcare Law Review during lunch so the professionals tuning in can fit it into their busy workdays or watch the video thereafter. Then in 2019, Sandy Toll, General Counsel for HANYS, joined me doing the legislative developments for the Healthcare Law Review, which is a great complement to my case law review that, we've been doing all along.
Great, thanks. And I remember those network meetings. I really used to enjoy them back in the day.
Yeah, it was nice close time with policyholders. Yeah.
Now, what were some of the goals you had in mind when creating Healthcare Law Review?
So my goal in creating each Healthcare Law Review, when I prepare it every year, is to provide healthcare providers and healthcare facilities with updates on court cases and legislation that came down in the preceding 12 months and impacts their practice of medicine. In addition to HANYS, we now present the Healthcare Law Review at a number of our insured medical centers, at regional medical societies, mostly the Medical Society of New York, and the House of Delegates for the Medical Society. Some of the topics that we've talked about, most recently, one of the big issues is anchoring and nuclear verdicts. So we've certainly covered that in our Healthcare Law Review, both cases where it's been raised as an issue on appeal and where the courts have said it wasn't preserved or we're not going to touch it. So we're still working on that one. We've addressed lack of informed consent. Consent cases are often a companion claim to a medical malpractice claim. So there's the portion that's alleging a departure from accepted medical practice. And then there's a second part that says that the patient wasn't given the opportunity to appropriately consent to the procedure, having understood all the risks and benefits of having the procedure versus not having the procedure. That'll become increasingly important when we talk about the case that's pending in the Court of Appeals right now, the San Miguel case, which is making a distinction between informed consent and medical malpractice actions. We've also discussed the quality assurance and peer review privileges that are under the education and public health laws, which protect those all-important quality meetings and documents and witnesses from discovery in a medical malpractice lawsuit. The Medical Indemnity Fund has been at the center of a lot of controversy in the last couple of years because it was closed for the first time and then reopened. And the myth is it's a fund which covers medical expenses of certain neurologically impaired infants and was essentially intended as a tort reform to bring down the cost of those cases, or the legal cost of those cases in terms of damages. And we've also addressed negligent hiring and credentialing claims against hospitals and practices. The various tolls to the statute of limitations has been a topic we've covered as well, particularly with the recent COVID, not so recent now, 5 years old, but the COVID tolls. but continuous treatment tolls and the Laverne's law for failure to diagnose cases are also important tolls to the statute of limitation. We've covered supervisory liability for physicians collaborating with nurse practitioners and or supervising PAs, liability of practitioners ordering a consult, and then the related limited liability of the specialty consultant who's performing that consultation. Another big issue lately is metadata, so the data behind the data, and that's frequently or almost always requested by plaintiffs' attorneys now in medical malpractice lawsuits, and it's being used in medical malpractice litigation. So we talk about how the courts have limited that and what its role is in medical malpractice litigation. We've talked about the doctrine of spoliation, which is when medical records or evidence are lost or destroyed and can have significant consequences for the party who loses or destroys that evidence. And then we've drawn the distinction between the alteration of medical records and addenda of medical records, and that there's a potential for punitive damages if there's an alteration of medical records, which is considered professional misconduct.
Well, thanks for all that. You certainly covered a lot of topics over the past years, and many of those, almost all of those, are extremely important to healthcare providers throughout the state. Can you tell our listeners about the San Miguel case?
So the San Miguel case is a medical malpractice case arising out of labor and delivery. The plaintiff mother was admitted to the hospital and labor was induced as she was beyond her due date. The physician tried vacuum extraction, but when that was unsuccessful, an emergency C-section was performed. The baby was born alive, but was in serious medical condition. He ended up dying 8 days later after being taken off life support.
All right, and I would imagine the family eventually filed a lawsuit.
Yes, they did. So the plaintiff sued the physician, the midwife, and the hospital where the delivery occurred, alleging medical malpractice on behalf of the deceased son, as well as on behalf of the mother. And they also alleged a lack of informed consent case, both on behalf of the decedent and on behalf of mom. And then they alleged a loss of services for the loss of the decedent's services. And the plaintiffs, effectively what the whole case was based on was plaintiff's allegation that she did not consent to the use of the vacuum extraction. And that's what caused the injuries, either, the actual vacuum extraction or the delay in doing the C-section because the vacuum extraction was done first.
Did this case go to trial, or was there a motion for summary judgment filed?
So there was a motion for summary judgment filed. The plaintiff mother did not allege that she sustained any physical injury during the delivery, only emotional delivery due to the physical injury of her fetus. So the defendant physician moved for summary judgment under established precedent in New York that says claims for purely emotional distress damages based on medical malpractice are not permissible if the baby survives the delivery.
Okay, and so what was the decision of the summary judgment motion?
So on summary judgment, first it went to the Supreme Court, so the lowest court, the trial court, and Supreme Court dismissed mom's medical malpractice action, but found there was a jury question or a question of fact regarding the informed consent cause of action, whether a lack of informed consent caused her emotional distress. And again, that was based upon whether the plaintiff mother consented to the vacuum extraction and whether that caused any injury to the fetus. It then went to the next level of courts, the appellate division, that agreed, holding that the precedent limiting emotional distress damages in these types of cases, prenatal tort cases, does not limit emotional distress claims in informed consent causes of action. And then the appellate division did something pretty spectacular in that it asked its senior court, the Court of Appeals, the highest court in New York, to overrule precedent and change the law so that mothers with emotional distress claims could bring medical malpractice and lack of informed consent claims, regardless of whether or not the fetus survives. And that has not been the law up to this point.
Wow. So we have new law right now, basically, right? This is hot off the press.
This is hot off the press. So the Court of Appeals rendered a decision on October 21st. And the Court of Appeals is a 7-judge panel. And the judges did not agree on what the outcome should be in the case. So the one particularly interesting aspect of this case is that the majority opinion was written for 4 justices, with 3 justices dissenting. So you can imagine just a slight change in the makeup of the court could change the outcome of this case. So the majority opinion, which was the 4 judges, confirmed that in New York, in both medical malpractice and lack of informed consent cases, the birthing mother may not recover for purely emotional distress damages arising from prenatal injury to her fetus if the baby's born alive. And the reasoning for that is if the baby's born alive, then the baby has their own cause of action for pain and suffering. So there isn't this legal gap where no one can recover, either mom for emotional distress or baby for pain and suffering. So this was the law before San Miguel, and it continues to be the law after San Miguel, with the clarification from the Court of Appeals that it applies equally to medical malpractice actions, which allege a departure from accepted medical practice, and medical malpractice actions that allege a lack of informed consent. So the court reasoned that this principle of stare decisis, which means that they should follow their precedent from other cases, that required them to keep the law as it has been since the early 2000s, when 2 cases were decided called Broadnecks and Shepard-Mobley, and that in those cases, they carved out this limited right for a mother to recover emotional distress damages only if the fetus does not survive. Because, of course, if the fetus doesn't survive and the fetus doesn't have any right to recover damages, and mom doesn't have any right to recover emotional distress damages, it was felt that that wasn't fair, that there was no right of recovery against a malpracticing medical provider in that situation.
Okay, that makes sense, and it's all very interesting, actually. Now, what about the dissents?
Okay, so there were 2 dissents. One was written by Justice Rivera and joined Justice Troutman, and then a second one was written by the Chief Justice. And, again, what I think is really interesting about these dissents is that there's 3 of them. So we only need one more judge to change over, and that will be the majority opinion, right? So Justice Rivera would have overruled Shepard-Mobley, the current law, and allowed a mom's purely emotional distress claim to proceed regardless of whether the fetus dies or not. And her position was, how can we treat these situations differently? It's still the same breach of duty by a medical provider to the birthing mother. And there shouldn't be this artificial line that's been drawn based upon what ultimately happens with the infant. Justice Wilson took a very different approach and would not have overruled Shepard-Mobley, or said you didn't need to overrule Shepard-Mobley to decide this case because this baby should or could effectively be treated as if it was never born alive, because after birth, the baby was largely on life support. And there are quite a few cases, lower court cases in New York, that have come down since Shepard-Mobley, where that argument is made by plaintiffs' attorneys that a baby that's born, so compromised, so medically compromised that they can't live without medical intervention, sort of life support type intervention, that they're not truly alive. And so therefore mom does have that emotional distress claim. They'd rather have that claim than the pain and suffering claim of a baby who lasts, for example, in this case, only 8 days. So, in order to recover for pain and suffering in New York, you have to have consciousness of your pain. So that's a challenging thing for plaintiffs' attorneys in this, situation, to demonstrate that the baby was conscious of pain and suffering during that brief period of life. And also the brief period of life makes that recovery a limited recovery. It's not going to be for as much money. Whereas the emotional distress claim that could include, years of emotional distress, even, PTSD is often alleged for the mother, for having been present when her fetus was injured and ultimately died. That's the much more valuable claim here. So plaintiffs' attorneys are usually trying to define their case as one for emotional distress for mom rather than pain and suffering for the infant. So what Chief Justice Wilson said was, let plaintiff prove both of those things. Go to court and prove both a claim on behalf of the decedent infant and mom, and then the plaintiff gets to choose which one they want to keep. So in other words, they choose the one that was, the bigger verdict. And that's something that I'm not aware of any precedent for. So that was a surprising dissent. But ultimately, those were the dissents, and again, they're mostly important here because of the slim majority. But the good news for the defense bar and for medical professionals and medical facilities in the state of New York is, for now, plaintiffs' efforts to expand emotional distress claims to a bigger group of plaintiffs has been rejected by our highest court. And that's a win for medical professionals and medical facilities that are battling huge medical malpractice verdicts, nuclear verdicts, and anchoring. So it's a great decision.
Well, thanks, Nancy. Thanks for that. It's nice to have a win for a change in the medical malpractice defense world, right?
Absolutely.
Can you give us a sneak peek at the upcoming healthcare law review?
Absolutely. So we're going to try something a little bit different this year. We hope you can tune in on December 9th at noon. Sandy and I will still be participating, but we've added our legislative counsel for MLMIC, Mark Craw, who is, very engaged with lobbying and what's happening on the legislative side. And he'll provide an update on legislative developments for 2025. Certainly the leadoff will be the Grieving Families Act, but he's got a number of other legislative things to discuss, with our audience. And we're going to try more of a panel discussion instead of the traditional healthcare law format, where, we're presenting case after case, law after law. We're going to have more of a discussion with an opportunity to send in questions, to, ask questions during the panel discussion and see how our audience likes it. And if it's popular, we'll do it again. If not, we can revisit how we've done it in the past, but we just thought we'd mix it up this year. So our topics will include expansion of emotional injury cases, like we've been talking about, through San Miguel, through another case that I'm going to talk about, through Grieving Families Act. We're going to talk about the scope of a healthcare facility's duty following discharge of a mental health patient. Those are some of the cases where somebody leaves care and then goes outside of the facility and commits a crime, and what the liability is on behalf of the discharging entity. We're going to talk about protection of that quality assurance process that we were talking about before, and get some important updates on the status of the medical indemnity fund, because the governor is really looking at that now. It had to be, as I said, it had to be closed because there wasn't enough money in it. And there's a mechanism that says if we start to run out of money for the infants that are currently in it, we'll shut it down until that amount of money comes back with refinancing it. So now a number of interests are looking at, what do we do about this? How can we move forward with the medical indemnity fund? Because it is a huge expense, but also a huge benefit to the participants in it and litigants in medical malpractice cases involving neurologically impaired infants. So we'll see how, where that goes. And then, we'll decide where to go for 2026. And we're interested in hearing everyone's input. So we hope people will let us know what they think.
Great. And Nancy, correct me if I'm wrong with this December Healthcare Law Review program. It's one of the largest. It's very well attended, the program that we put on with HANYS, correct?
Absolutely. We keep getting, I think one year it was close to 500. So we really do get a lot of people participating. And the nice thing about it is if you register, and as happens with healthcare providers, if you register and then the last minute you have something going on at the time that we're presenting it, you'll be on a list that will get the video. So you won't miss out on all the information that is disclosed.
Oh, great, great. And listeners, we will start promoting the webinar probably the beginning of November, and we'll have it on our social and on our website with links to register so you can hear Nancy and now Mark together with HANYS present their new format, which sounds to be really kind of exciting.
Well, I hope so.
Yep, no, change is always good, right?
That's right. That's right.
And that's the verdict on Healthcare Law Review. Stay connected with us on Facebook, LinkedIn, Instagram, and X for information on our upcoming webinar with HANYS in December. This podcast is for general purposes only and should not be construed as medical or legal advice. This podcast is not comprehensive and does not cover all possible factual circumstances. Because the facts applicable to your situation may vary, or the laws applicable in your jurisdiction may differ, please contact your attorney or other professional advisors for any questions related to legal, medical, dental, or professional obligations, the applicable state or federal laws, or other professional questions.